Hello landlords, it's Ernie, your landlord attorney. I'm back and today we're talking all about rent relief. The Texas Eviction Diversion Program is still going strong. So as of filming, the statements I just made on the video that you are currently watching were absolutely 100% true. However, that's changed, and so you're going to want to stick around for the current update that we just got days ago. But is it mandatory? If you don't know, you need to listen. Let's get started. So the state of Texas recently announced that Texas had hit the 1 billion mark in terms of rent relief funds that had been distributed to residents of this state. The first state in the U.S. to actually distribute $1 billion since February. And so the question remains, if Texas has already doled out $1 billion, there really can't be much left in the fund. Not true. In fact, there are still $900 million left. So rent relief is alive and active.
Wrong. This no longer applies. As of November 5th, 2021, the Texas Rent Relief Program has stopped accepting applications. So if you have not submitted an application yet, you apparently can't. And so if you'll go to the website, you'll see that an update is now available on the website letting you know that active applications are no longer available. If it turns out that you have a pending application, that's totally different. It appears that they will continue to process pending applications until the funds run out. However, at this moment, they are not accepting any new applications. What is unclear is whether or not that applies to all agencies. My guess is that the rent relief, which is the main statewide overarching agency, having had run out of funds, means that everybody else is going to run out of funds soon if they haven't already. And so what you'll want to do is you'll want to contact the agency involved in rent relief. You may have multiple agencies in your jurisdiction. Contact them to find out for sure.
If your tenants qualify for rent relief, don't be surprised if they've stopped paying rent and they let you know, we've put in an application and we're seeking rent relief. But the question for you is, what happens then? I mean, can your tenant simply stop paying you rent and tell you you have no cause of action against them? In most cases, they can't. However, it might benefit you to cash in on $900 million still left in the state of Texas. You'll find that Texas has actually been more successful than most other states in terms of the speed and the efficiency in which these funds are distributed. It took a while. If your tenants qualify and you're interested in collecting rent relief, you absolutely can, but it's not a requirement. Landlords, if you've enjoyed the video so far, or if you tend to enjoy the videos that you see on this channel, don't forget to give us a like. And if you haven't subscribed yet, please consider subscribing. As always, your comments are welcome. Comment down below if you have something to say. So as I mentioned earlier, you do have the right to obtain rent relief where your tenants are eligible and you have announced to whatever agency is handing out these funds in your local jurisdiction. Those funds are still out there, and if your tenant hasn't paid the rent and they are eligible, why not take it? What effects, though, does this have on a pending eviction matter? So let me paint a scenario for you. You have sought out rent, your tenant has done nothing, they've gone radio silent, and so you have no idea what they've filed for or what they're eligible to receive. So naturally, if in your jurisdiction, all things are back to normal, in quotes, right? Send that notice to vacate and begin the eviction procedure. If you've done that, and say you're headed to trial, and this is kind of the typical situation in these cases, you're about a week out and your tenant is scrambling and they call you and say, look, I just submitted my application for rent relief. What do you do? Well, you could reciprocate and you could say, you know what, I am also going to submit my application for rent relief. Now, the moment you put your hat in, your eviction stops and cannot proceed. In fact, you'll have to announce to the court at the time of trial if you are seeking rent relief assistance along with your tenant. You'll have to announce to the court that that is the case, and your case will automatically be abated for 60 days. The goal of the rent relief program is to prevent eviction, so that if you have an active eviction in place, you're not required to dismiss it or close it down. You don't get an automatic no, but you do hit the pause button. So you'll hit the pause button, the case gets abated, and if funds are received, the case will be dismissed, and all record of that eviction will disappear. There will be no record of the filing, and there certainly will be no judgment. So you get the funds, you agree to certain stipulations regarding late fees and the amount of time that the tenant is allowed to stay before you can demand possession again. Depending on where you get the funds, your stipulations may be different, but these are kind of general ideas about what's going on in most cases. Your case is dismissed, you accept the funds. Generally speaking, it's for months in the past and can be for months in the future. And so if, for example, you accept rent in month 0 and you've gotten all the negative rent from the other months prior, but you receive 3 months of rent in advance, well, naturally you can't do anything to demand possession over the course of those months, but you can set yourself up to terminate the lease if you are on a month-to-month. That's a different story. As far as your case goes, though, even if it's still up in the air, even if it's still a question of the tenant's eligibility, you put pause, 60 days. Now, let's say in the middle of this, you decide, you know what, it's not worth it. I'm not interested in keeping this tenant, so they could pay me all the rent plus 3 months, and I would still reject it. At any time, you can withdraw your interest in receiving rent relief funds by sending a written document to the court, illustrating to them that you are no longer interested in these funds and that you would like your case set back on the court's active trial docket. Some days later, you'll receive a notice from the court letting you know when that date is. You show up and you can proceed as you would have before. However, you do miss out and forego any of those fundings. And it is possible that the rent relief agency, because you have rejected those funds, but your tenant is found to be eligible, has the right to send them directly to the tenant. That's its own ball of wax and its own issue, but there's nothing improper about that. The rules will allow that if the landlord rejects the funds, the tenant can receive them directly from the rent relief agency. However, again, if that's not an issue to you and you want your case back on the docket, you must submit that written notice, because if you don't, once the 60 days of your abatement elapse, your case is automatically dismissed, and you would have to start the entire process over. So if you do decide that you want to take a chance and see if your tenant is eligible, after you have filed an eviction, you will get an abatement. And if during that time you decide, I'm not interested, you have to send a written request to the court to make sure that your case is not dismissed, but that in fact it is reset on the court's docket. Otherwise, if you accept funding, the case will be dismissed and everything is fine. Now remember, if from the beginning you have rejected any kind of rent relief and your tenant comes to you and says, look, you simply cannot evict me, I have a rent relief application in process. That's simply not true. If you show up to court and the tenant insists that they have a case number, if they insist that they have an award letter, even if your tenant has received funds from the rent relief agency, you are not required to accept them. You can reject them at each of these points and still move forward with your eviction. Now, whether you want to do that or not is entirely up to you, but you do have that option. You are not forced to accept the rent relief funding, nor are you forced to abate your eviction, nor are you forced at any time to withdraw your intent to evict or your demand for possession simply because the tenant has applied for rent relief. Landlords, I hope as always that this has been helpful for you. While you are proceeding with your evictions, check the rules in your local jurisdiction. Definitely in the state of Texas, if you want to proceed, landlords, with your eviction, you are not required to accept rent relief funding. However, if you do, please understand that your tenant can receive them because you have rejected them, and that may cause its own complications for you. If you're interested in it and need to talk to somebody about it, there's a lot of information on the web, but you can call us, reach out to us by phone or by text or by email. I welcome your questions, even down in the comments below. Let me know what you're thinking about this and whether you still have questions about rent relief. However, if you see my face here and haven't subscribed yet, please click. We welcome your subscriptions. If you like this video, give us a like. There's a video here that YouTube seems to think that you will enjoy. But until next time, happy leasing.